This story begins in the late 1990s with a dental assistant named Cheryl M. She was flown from Alberta to Las Vegas for drilling lessons, part of the flashy Las Vegas Institute for Advanced Dental Studies program. There, her own Alberta dentist practiced on her, drilling her natural teeth straight down for porcelain crowns. What she brought home wasn't a glamorous smile, it was pain. She filed a complaint with the Alberta Dental Authority, but it was reviewed and dismissed. In later cases just like hers, the authority took very different action. One Edmonton dentist, Dr. T.H., also trained at LVI, used those methods to straighten 6 lower front teeth. Orthodontics was offered, but the patient wanted the fast way. The teeth were drilled, crowned, and complications followed. Root canals, pain, disappointment. The dentist had warned of the risk and a common one. And under the law, patients can choose riskier options when fully informed. But the Alberta Dental Authority saw an opportunity. They framed this textbook, Instant Orthodontics, as a serious violation and came down hard. A fine, legal costs, and a public spectacle meant to warn other LVI dentists. Yet the irony? The same authority had once promoted LVI. Their own newsletter ran full-page ads for the Canadian lab that pushed the LVI brand. That lab's owner was even granted honorary membership in the Alberta Dental Association. When complaints about LVI-style treatments began surfacing, the link was politely ignored. Drilling 6 front teeth became a crime against nature. The dentist was fined heavily and left with crushing legal bills. The expert report used against her was allegedly altered between the hearing and the court appeal, and requests for the original have been ignored ever since. Altering an expert report could be as serious a violation as the dental work itself. Then came the crackdown on advertising. Another Edmonton dentist, also LVI trained, was sanctioned simply for using the words cosmetic dentistry in his office name. The authorities' obsession with advertising rules ballooned into a 33-page manual banning even before and after photos of teeth. One frustrated dentist pointed out that plastic surgeons could still post their breast reduction results online. Why couldn't dentists show clean white smiles? But the rule enforcement web backfired. While lawyers and investigators chased ad infractions, real patient complaints sat for 5 to 9 years awaiting a hearing. Many were quietly dismissed just to clear the backlog. Down in Lethbridge, another case arose, again linked to LVI-style orthodontics. The LVI program's top orthodontic instructor, an Australian dentist, was eventually sanctioned in her own country, banned from practicing orthodontics altogether. In Calgary, another LVI poster dentist and promoted as a TMJ expert, treated a patient's headaches with full-mouth crowns. The procedures were unnecessary and painful, yet his fine was only $30,000, less than the profit from the case. The patient wasn't refunded a cent. The system seemed focused on collecting its own penalties, not ensuring restitution. Other LVI-related TMJ and cosmetic cases dragged on for years. One dentist simply moved to Saskatchewan and set up shop before her mild reprimand was even finalized. Her case summary didn't mention LVI at all. Then, another Edmonton complaint surfaced, tied to the Anterior Growth Guidance Appliance, or AGGA, already making headlines in a CBS investigation for pushing teeth out of bone. The Alberta Dental Authority's response? They appointed an LVI-trained dentist to review the complaint, since the practitioner had followed LVI protocols, and LVI courses were still approved for continuing education credit. The complaint was dismissed as within the standard of care. That single decision exposed a deep flaw. If the authority recognizes a course, it effectively shields questionable practices that come from it. Only recently has the American Dental Association removed LVI seminars from its approved list. Alberta has yet to follow. Back in Calgary, yet another LVI-linked dentist faced concerns over orthodontic complications. Her disciplinary summary also avoided any mention of the LVI connection, even though she had been featured prominently in their marketing magazines. Today, more patients with LVI-related complaints are still waiting for resolution, some for years. Others have simply given up, exhausted by the process. Investigations are often handled by non-dentists, and oversight committees seemed determined to keep any mention of LVI off the official record. In the end, the Alberta Dental Authority has arguably spent more money silencing whistleblowers than investigating the complaints themselves. As LVI's reputation declines and its seminars lose followers, the profession faces an uncomfortable truth. Their carefully managed attempt to rein in the problem quietly, without admitting fault, has failed. And the public? They never knew if their dentist's choice of dental seminars was going to mislead them into irreversible, risky, and expensive dental procedures that could leave them with complications for a lifetime.